those monies are to be utilized, are to be invested, not invested, utilized for the purposes of execution of the object of the trust. But sometimes it is impossible, or rather sometimes it is not warranted to utilize such money for the purposes of execution of the trust. Now, in such situation, what is the job of the charity commissioner and what is the job of the assistant charity commissioner? Assistant charity commissioner comes into play in this manner. Whenever there is any money that is to be invested because it can't be utilized for the purposes of the trust, then that money can be invested in accordance with section 35. That money can be invested with the schemes of RBI. That money can be invested in the cooperative banks recognized by the state for that purpose. That monies can be invested for the public securities as defined in the definition section of the Bombay Public Trust Act. But let us say that the trust wants to utilize its money for different purpose. Let us say that the trust wants to invest it in a particular partnership or other a company or for the purchase of the shares of a particular company. Then for such manner, the trustees will still have to approach the charity commissioner, in this case the assistant or deputy charity commissioner. They will have to take permission from the deputy charity commissioner before such investment takes place, and only then the monies can be utilized for that purpose. There are also reasons, or rather there are also circumstances where the trust wants to purchase a property. Trust wants to purchase sometimes it is warranted that the trust should invest the monies in purchasing of the property. The purchase cannot take place unilaterally on the basis of the decisions of the trustees. But such purchase can take place only upon taking sanction or taking permission from the charity commissioner. In this particular aspect, there can be a general order also and a special order of the charity commissioner as to in what manner the monies of the trust should be invested. Now, the trust, as I have told you, that the the charity commissioner has to decide these applications filed and grant the permission if the charity commissioner is satisfied that such application is genuine and such application is not malified or not made with a dishonest intention, then the permission should be granted. There is also another provision, or there is also another manner in which the trust can invest its money. That is by creating first mortgage, in the sense that by advancing the money in lieu of the first mortgage of the property. The words in the legislature are very clear. They are first mortgage in the sense that the second mortgage or the second charge on the property cannot be permitted to be created by the trust. And only if the property is being mortgaged to the trust against the money that is being advanced and that property is the first mortgage, then only the money can be invested. And it is always necessary that the property which is mortgaged, the value of such property should be 1.5 times than the money that is being advanced. And all this is subject to the supervision of the charity commissioner. Now, what if you don't obtain the permission? What if you don't obtain the permission under 35(1) and still purchase certain property? What happens to the validity of such transaction? Well, the courts have held that the transaction that is undertaken on account of utilizing the trust money and by purchasing the property, immovable property of the third party, utilizing the trust money, such transaction can't be rendered invalid, because on execution or other registration and upon consideration changing hands, the legal title in the property comes to the trust. Therefore, once the property vests with the trust, the property's title is valid. That is first. But the only remedy that one can have against such dereliction in duty in obtaining the permission before purchasing the property, that remedy is to go to the chief magistrate or to the criminal courts under section 66 and seek prosecution of the trustees. But apart from that, one can't do anything. And also, that is the same situation when the trust wants to invest money in the shares of a particular company. Now, moving from this, we come to what is the situation when one has to sell, or a trust has to sell an immovable property. Now, immovable property of the trust is really speaking the property of the public, because the public property, in the sense that properties of the public trust are always under the pronouncement of the Supreme Court judge, Supreme Court decisions are always considered to be the public properties. And therefore, these public properties are to be protected with utmost care, with utmost prudence, and with utmost vigilance. And therefore, there is a separate section, or there is a separate procedure, or a self-contained code, as I may use the term, for the purposes of selling such properties of the trust. So really speaking, there is a restriction, direct restriction on the trustees from selling, exchanging, gifting away any immovable property of the trust. There is a prohibition on the trustees to create a lease in favor of a third party of the trust property for a period more than 10 years if the property is agricultural property, agricultural land, or for a period more than 3 years if the property is non-agricultural. In all these circumstances, you must go to Charity Commissioner, obtain a permission or sanction, as it is called, and only then proceed with the process of selling the property. What is the effect of this? Well, the effect is the Charity Commissioner, using this instrument or using this particular section, can maintain a close watch on what properties are being sold, A, what price they are being sold, and whether any properties are being sold in the interest of the public trust. Now, that takes us to a very important aspect as to the procedure that is to be followed by the Charity Commissioner while deciding such applications filed under Section 36. Now, first of all, when an application is filed under Section 36, a sanction can be either refused or granted. If there is a grant of any sanction, then such sanction can always be subjected to certain conditions that will have to be fulfilled before any execution of any agreement, so as to create third-party interest as envisaged in 36(1). Now, as per the new Amendment Act, as I have told in 2017, there were massive changes that were brought into effect in the Maharashtra Public Trust Act. A lease is not permitted for a period which is more than 30 years. So even either with or without sanction, you cannot lease the property of the trust for a period which is more than 30 years. Therefore, that is the new provision that has come into effect, and you can't execute the lease which is for more than 30 years period. There are certain conditions that may be imposed by the Charity Commissioner while granting such sanctions. But before that, what is really important is that while deciding such applications filed under Section 36(1) and before granting sanctions, the Charity Commissioner must appreciate or rather ascertain whether this particular property is being sold out of compelling necessity. That is, whether the public trust has faced with the compelling necessity to sell the property. That is first. Second, whether such sale is going to benefit the trust. And third, whether such sale is adverse to the interest of the beneficiaries or the trustees. Or to say otherwise, whether you are obtaining correct value or correct consideration at the time of selling the property under Section 36. So these are the broad aspects that I am saying. These are the broad aspects as laid down or as fixed by the High Courts by virtue of numerable decisions that the Charity Commissioner must apply its mind, find answers, give findings to these main three important cardinal questions, and only then either permit or refuse to grant sanction for the sale of the property or other alienation of the property by any means mentioned in 36. Now, after that, Section 36(2). What happens if the sanction is granted and you want to revoke the sanction? Now, the sanction can be revoked only if such sanction is obtained by playing fraud or misrepresentation on the Charity Commissioner. Otherwise, the sanction once granted is final. The only remedy that is available to you is go in appeal. That is in the Bombay High Court appeal by way of filing the writ. There is no other appeal provided. There are Section 36(2) and 36(4) that I will come to later. But I'll just first talk about as to how this 36.1 operates and what is the procedure for dealing with this 36.1. Now, as I mentioned to you, first of all, the charity commissioner has to find out whether there is a compelling necessity, whether the alienation is just, fair, and in the interest of the trust, and whether the alienation adversely affects the interest of the trust. The procedure, detailed procedure as to what are the aspects or what are the headings under which you must file your pleadings, that is given in Rule 24 of the Bombay Public Trust Act rules. Now, the power under Section 36 are unfettered powers, and these Section 36 provisions will have to be obeyed, will have to be adhered to, will have to be complied by each trustee or each public trust, regardless of what their instrument of trust is. And therefore, it doesn't matter whether your instrument of trust permits the trustees to sell the property. You still have to, at the time of sale of the property, you will have to come to trust charity commissioner and obtain the sanction. Now, the procedure that is generally followed is this. Generally, a public notice is issued when a public trust decides to sell the property, let us say. Then upon decision, they first will have to file a resolution of the trustees. Please remember that a trust property cannot be sold unless all trustees concur or join in execution of the decision. No matter what, even if one trustee says that I don't want to sell the property and wants to stand out, then also the only remedy that is available to the remaining trustees to obtain the order of the court for making him join for execution or appointing a new trustee, or obtaining the order from the court for execution in such manner. But no trust can take steps for execution of the sale deed or other any agreement for the purposes mentioned in Section 36.1 unless all trustees come together and join in execution of the agreement. Therefore, it is necessary to have the resolution of the trust. Once the resolution is passed, as per the decision given in Shailesh Developers and various other judgments, sometimes or rather many a times the practice followed by the public trust is to invite the public notice, and that public notice will envisage the various terms and conditions of the agreement for sale or filing the bids. Once such public notice is issued, the interested parties can put in their bids. As per the judgment of the Supreme Court of 1979, one of the terms of such participation by way of public by way of bidding is you will first have to deposit the earnest money amount, EMD, and upon filing of such bids, the application is generally made in favor of the person who is the highest bidder. Once the application is filed before the charity commissioner, then the charity commissioner, if he is not satisfied with the fact that the trust has decided to sell the property to a particular bidder, if he thinks that the property is still undervalued or the sale is going to be undervalued, and rather he thinks that there is a possibility that there may be other buyers who may come in at a higher value, then he still has the authority to issue another public notice and call for another public auction of the bidders, where the bidders are free to participate and give their options or they give their bids for purchase of the property. So really speaking, it is the charity commissioner who will decide who is going to be the seller. Now, that doesn't mean that every time charity commissioner has to act mechanically and decide to sell the property to the highest bidder. It doesn't happen like that. Sometimes the charity commissioner also takes into account the fact, the antecedents of the particular highest bidder, the financial capacity of the highest bidder, and may decide to give it to someone who is more stable, who has better reputation, who has more willingness to adhere to the terms of the charity commissioner. So it's a very intense and a very judicial job that the charity commissioner has to conduct and undertake at the time of sale of the property. Apart from that, what is important is that the conditions that may be imposed by the charity commissioner may vary from time to time. For example, the charity commissioner may impose a condition whereby at the time of giving the sanction that the entire conveyance has to be executed within a period of 3 months, let us say. And for some or the other reason, the purchaser fails to execute such conveyance for more than 3 months, even after taking extension after extension, even after 2 years or 3 years, he is unable to execute the conveyance. Then in such situation, the charity commissioner is not powerless to simpliciter or to mechanically adhere to the sanction already given. If he is of the opinion that after a period of 3 years, the amount or rather the value of the property has increased, then he can still call for the fresh bids and issue a fresh sanction, not in favor of the stale competitor or not in favor of the earlier one, but can issue the fresh sanction in favor of someone who may be the highest bidder in the second round of bidding. Therefore, the powers under section 36(1) are really speaking a very wide, are for the purposes to protect the interest of the trust. Every time the public, the charity commissioner has to decide an application under section 36, he has to decide whether this particular transaction is going to benefit. Secondly, whether this particular transaction is out of the compelling necessity, and whether you are getting the appropriate market value or whether you are getting the proper value for the property. Now, reasons for compelling necessity may vary, but for the trusts that are situated in Mumbai and having wide or rather humongous amount of lands in their name, the major problem or the reason or the compelling necessity is the encroachment. So sometimes it becomes impossible or rather impractical for any public trust to keep defending or keep taking steps to vacate the trespasser or get rid of the encroachment. And in such situation, you can very well go before the charity commission under 36 and try and sell the property after obtaining the permission on the reason that the property which is going to be subject matter of sale is, really speaking, is the property which is now impossible for maintenance for the trust. Because sometimes it happens that the trust invests more money in litigation than the actual property of the value. And therefore, it is generally advisable that the property that are encroached, the property where the slums have come up, the trusts are generally go for sale of the properties with the permission under section 36. Now, coming back to how, in what circumstances the provisions, the sanction that is granted in section 36 is revoked. As I mentioned to you earlier, the sanction can be revoked only on 2 grounds. First, whether the fraud, misrepresentation and concealment of facts has been practiced by the applicant or by the trust at the time of obtaining the permission. And if so, then the charity commissioner, after revoking the sanction, will give a period of maximum 1 year to the trustees to recover the property. Now, there are cases where the sanction has been utilized and sanction has now merged with the execution of the conveyance and the property has now transferred in the hands of the purchaser. Well, in such cases, then the only remedy that is available for the charity commissioner per se under section 36 is to recover the benefits or recover the advantages that have been received by the trust and deposit them under the separate account or other under the public administration funds, public trust administration fund. That is the limited remedy that is available to the charity commission under section 36. More importantly, such revocation is absolutely fruitless or rather becomes ineffective the moment the type or nature of the property changes from the public trust property to private trust, private property. Once a property becomes a private property, based on the sanction obtained under section 36, either rightly or wrongly, then that property cannot be the subject matter of section 36 revocation because it has changed its character. It has gone outside the purview of the Bombay Public Trust Act, and therefore the only remedy that may be available to the charity commissioner is to seek recovery by filing a suit, or for that matter, the only remedy available to the people interested or the persons interested is to file a suit after obtaining the sanction of the charity commissioner under section 50. Apart from that, one must remember that ex post facto sanction or other the sanction which can be granted or which may be granted after the sale is completed is no sanction. It is of no use. It is only for the limited period that by way of Amendment Act of 2017, the state government has said that the sanctions that were given or other the transactions that have taken place without obtaining sanctions before the Amendment Act was brought into force, that is October 2018, those sanctions, ex post facto sanction can be given by the Charity Commissioner. But even for giving such sanction, Charity Commissioner has to be satisfied that there were extraordinary circumstances for entering into such transaction. And also, apart from that, he has to satisfy himself on the ground that there was compelling necessity, there were emergent situation, consideration was not less than the market value, reasonable efforts to secure the best price was taken or were taken by the trustees, and no benefits derived out of transaction of the trustees, and document that has been executed by the trust in favor of third party is registered. Because eventually, if one reads section 36, you will understand that the Charity Commissioner is a custodian of the properties of the trust, and therefore Charity Commissioner has to take every action possible to protect the properties of the trust. And therefore, the 36, really speaking, is a very vast section and really speaking generator of vast amount of litigation in the office of the Charity Commissioner. Now, moving on from section 36. Now, you must understand that the entire procedure, really speaking, was though in place, was very unwritten, was not codified ever, and even to an extent till date not codified, such as invitation of bids and everything, is the procedure that has taken, that is cemented or that has taken birth out of the judicial pronouncements. And one such judicial pronouncement, which is really important for everyone to read, to understand what is the scope of section 36, is the full bench judgment of the Bombay High Court, that is Shailesh developer case, and the citation is, please take down, is 2007 volume 4 all MR 100. This is the judgment of the full bench of the Bombay High Court that lays down what are generally the functions, what is the jurisdiction of the Charity Commissioner while exercising its powers under section 36. Now, so really speaking, the Charity Commissioner's job is not simply to restrict to refusal or permitting sanction. It goes much beyond that. It has a wide amount of obligations to, in that sense, exercise at the time of granting or refusing to grant the sale or sanction for sale of the property. Now, moving on from this, powers and duties and restrictions of the trustees is something that also creates a connection with the powers of the Charity Commissioner, because every trustee is under obligation to utilize the money only for the purposes of the or objects of the trust, and he must undertake every action possible to ensure that the trust money or the trust funds are utilized for the objects and the purpose of the trust. Otherwise, he is liable for punishments and rather liable for various other punishments as envisaged under section 41D and section 66 and section 41E. Therefore, that also is one of the important aspects. Now, moving on from there, for the purposes of supervision, for the purpose of control of the control, to ensure control on the properties of the trust, the Charity Commissioner, Assistant Charity Commissioner, as well as Deputy Charity Commissioner is invested with very wide powers of inspection and supervision. What really happens, or what is really codified in these sections, or section 37, is that the Charity Commissioner or Assistant or Deputy Charity Commissioner has the power to call for any document of the trust, to call for records of the trust, call for any bank account, call for any audited balance sheet, call for any annual reports of the trust and inspect them. They can also, upon investigation or other order inquiry, if they find that there is any loss, and they can also call the trustees to give an explanation if they are not satisfied with the particular finding or rather particular document that has been produced before them. And if they come to the conclusion that there is a loss caused to the trust on account of irregularity, management, negligence, and breach of trust of the trustees, then assistant or deputy charity commissioner or any authorized persons by the deputy or assistant charity commissioner shall file a report to the charity commissioner. Means assistant or deputy charity commissioner will file a report before the charity commissioner, and authorized persons appointed under the act will have to file the report before the assistant or deputy charity commissioner. Likewise, when there is a report already made to the assistant or deputy charity commissioner by the special person, or if there is a complaint made by anyone who is interested in the functions of the trust, the assistant or deputy charity commissioner can call for explanation from the trustees, and under section 38, after conducting appropriate inquiries as may be required to understand the nature of the irregularities or understand the trustees' actions or inactions, they can render finding on such aspects and submit its reports to the charity commissioner. Now, what charity commissioner does upon receiving the report? The charity commissioner, upon receiving the report and after having gone through all the records produced before it, can also give a hearing or has to give a hearing to the trustees or the person connected therewith for explanation or for seeking explanation. And thereafter, it may determine the misconduct, negligence, and breach of the trust, quantum of such loss, whether any trustee is responsible for such loss, it can give the finding to that effect, amount of loss to be paid to the trust, or even send the matter for further inquiry. If it thinks that the particular aspect has not been inquired properly, then it can still send the matter back to the assistant or deputy charity commissioner for further investigation, further inquiry, and thereafter, naturally, the assistant or deputy charity commissioner will undertake the further inquiry and again file the report. Now, this doesn't end here. What is more important is, upon giving such or understanding that there is such kind of or some kind of irregularity committed, there is some kind of negligence that is being undertaken or caused, and there is some kind of loss that is being caused by the inaction or the negligence of the trustees, the charity commissioner has wider powers, and those powers we will see in section 41D, 41E, as also section 41F. That is a newly introduced section. But before that, let's understand what are the powers that the charity commissioner has, or rather the assistant or deputy charity commissioner has, for general administration. Now, there are two aspects of powers, or there are two instances that are codified, whereunder the assistant or deputy charity commissioner can issue appropriate directions or necessary directions for better management or administration of the trust. These directions, as I told you, can be issued for better management of the trust or administration of the trust, or such directions can also be issued when the assistant or deputy charity commissioner is notified of the fact that a particular property of the trust is likely to be damaged, is likely to be alienated unlawfully, is likely to be removed from the jurisdiction of the officer or the assistant or deputy charity commissioner, is likely to be improperly alienated and likely to be wasted accordingly. Now, in such situation, the charity commissioner, assistant charity commissioner, can issue appropriate directions. Such powers under 41E to an extent also include issuing appropriate orders to arrest such loss. So before any property is alienated, appropriate directions can be issued under 41A to ensure that such loss is not caused to the trust. It may be of anything of it may such directions of or can be in the nature where the loss has to be or eventually has to be prevented. For example, a trust tomorrow or trustees of a trust tomorrow pass a resolution saying that the funds of the trust can be given or can be utilized to award scholarship to the children of the trustees. Now, there is a statutory embargo under the Bombay Public Trust Act as well as under Indian Trust Act, that no trustee can take or derive benefit from the properties of the trust, from the monies of the trust. Now, therefore, any benefit that is being derived by the trustees by giving such resolution or by passing such directions will naturally become unlawful. And if someone complains to the assistant charity commissioner that look, there is certain resolution or resolution of such nature is passed, and therefore you must act immediately to ensure that the trust funds are not wasted by giving the scholarship to the trustees' sons, and you must do something, then under 41A, it can issue appropriate directions. Or for that matter, let us go a little step before issuing the resolution. If the assistant charity commissioner is made aware of the fact that the trustees or trustees are going to hold a meeting to pass certain or this kind of resolution, whether they may decide to pass on the benefits to the trustees' children, then also the appropriate directions can be issued by the assistant, whereby it may say that you can hold a meeting, but you cannot pass such resolution, in the sense that insofar as the agenda of the meeting relating to this particular resolution is concerned, you cannot take up for discussion. Such kind of directions can be passed. Basically, this power under 41A, though limited in nature, is an administrative power. It's not a judicial function. It has to be exercised in manner where the functions of the trust will have to be streamlined, where the functions and the administration of the trust is done in such a manner that the objects of the trust are fulfilled. So these powers, really speaking, are little limited in nature. These powers cannot be utilized for the purposes of removing a trustee, or for example, for if the assistant charity commissioner, if he is of the opinion that for administration or better management of the trust, I am going to appoint an ad hoc committee, then such directions are not good in the law. The assistant or deputy charity commissioner under section 41A cannot interfere with the election process. They cannot pass injunction order as defined under section 38 of the Specific Relief Act, whereby they may prevent someone or other the trustees from holding meetings. They cannot remove a trustee under 41A. Even they can, to an extent, appoint a trustee, because that powers is by virtue of section 47. Therefore, that can't be utilized in consonance with section 41A. Therefore, they don't have these powers under 41A. The powers under 41A are quite limited in nature. And 41A being administrative power in nature, no much inquiry needs to be done at the time of issuing the order under 41A. There is one judgment of the Bombay High Court, that's Ramrao Kauthade versus Vijay Kumar Shetty, 2004 to all MR 211, wherein the High Court had affirmed the decision, or rather confirmed, or did not set aside the decision of the assistant charity commissioner, wherein the charity commissioner had appointed a committee to undertake the functions of the trust or functions of the trustees for a limited period. In that case, what had happened is that the trustees had tendered resignation. Another set of trustees were to be appointed. There were two warring groups, and therefore the change reports, which were two in numbers, were being contested by both the groups. And therefore, there was no certainty as to when the elections can be held. And therefore, the assistant charity commissioner appointed a committee and also set down the date for election. And in the interregnum, vested the powers of management and administration on this particular committee. So such nature of powers or such nature of order can be held to be valid, but not the comprehensive appointment or other final appointment of the trustee or removal of the trustee is not permissible by invoking the powers under section 41E. Now, coming to other powers of the charity commissioner, there is a power vested with the charity commissioner, assistant charity commissioner, deputy charity commissioner under section 41B. That is the power of initiate or institute inquiries. Now, what happens if the public interested or the person connected with the trust or beneficiary for that comes to know that there is some problem or there is some irregularity in the trust, or as we have seen, the report is filed by the special auditor under section 37, and the report says that there is some occurrence of, or there are some instances of negligence, there are some instances of irregularities, breach of trust. Then what happens? Then also, there are inherent powers given to the Assistant Charity Commissioner, Deputy Charity Commissioner, and Charity Commissioner under Section 41B to institute inquiry. These inquiries can be instituted suo motu, which is very important, or on a complaint from a person. So, single person having interest, having connection with the trust can also initiate such inquiries. Now, that these inquiries will have to be done in accordance with the prescribed format that is in Bombay Public Trust Act rules, which includes adducing evidence and everything. And these inquiries can be held by the Assistant or Deputy Charity Commissioner himself, or they can appoint an officer and conduct these inquiries. These inquiries, as I mentioned, will have the powers given to adduce evidence, then call for the records, call for the documents, and thereafter give its finding, which will be finding on each and every aspect of the inquiry.